Mr. Allison, I gather your client, who obviously arrived during the hearing, had difficulty hearing. I hope this location is better. I'm afraid there's no hearing loop in the courtroom, so there's nothing technically we can do. If a request had been made in advance, we could have moved to a different room.
Understood.
Good, and there is always the advantage of being able to watch it on iPlayer or whatever it goes on.
Afterwards, yes. Catch up.
Yes, Miss Matson.
My lord, my ladies. So, picking up where we left off and revisiting a point made by my lord in respect of the construction of the document and the date that we are concerned with, if I could start by taking us to Cherry Tree to make good, and having considered your point, my lord, I think you were, I know that you were all right, and I didn't quite put my submission the way I wished I would have had. So if I could revisit the point about timing of when documents and information need to be relevant. Behind tab 6, 57 of the authorities bundle, paginated on the bottom right-hand side, we have, if I could invite you to just read page over the page of the 58 and A, which you're invited also to read by my learned friend.
So, this is 50 of the authorities.
57.
57 of the authorities.
57.
Yeah.
Yes, my lord.
You mentioned page 58A, which confused me. Maybe I misheard.
Forgive me, I might have misspoken.
Yeah.
Forgive me, my lord. So it's 57, and the quote of Lord Hope.
At 57, I've got Lord Justice Lewison, paragraph 124. Oh, and then
he
the
quotes
quotation
Lord
of
Hope.
Lord Hope.
Yeah.
Thank
Yes.
you, I'm sorry.
No, thank you.
And you want us to read it?
And if I may ask you, my lady, and just over the page to 8B.
There must be a word missing. There must be there would be much to be said. With this argument. We read this with Mr. Allison's.
So the 2 points that I'd like to make in respect of these is, one, my lord, as you pointed out, the relevant time when we are considering is not subsequent sales of the transfers, but of course the date when the contract was made. So we are dealing with whether or not it would have been reasonable to the parties to the contract, the transfers, at the time they were made, to have access to the leases themselves, whether it would be background knowledge reasonably available to those parties. Now I say, considering the timing and considering the parties, the judge was correct to find, as he did, that it is more likely than not these transfers were available to those parties. And as he found at page 112, although he had no direct evidence, the point made by my learned friend, in respect of the availability of these transfers to the freehold purchasers, there is no reason to suppose that diligent conveyancing solicitor would not have reasonably had access to them. Now, I say actually would be rather surprising in my submission if, as the conveyancing solicitor, did not require these from the common vendor who was the developer in respect of this development. I say therefore that the judge was right to find the fact that he could take into account the leases and their relevant provisions. Returning then to the point made by my learned friend on Cherry Tree and whether or not we should have a more restrictive construction of these documents, because the leases themselves were private documents Now I say again that the judge was correct to distinguish cherry trees for the reasons that he gave. Those reasons are found in paragraph 71. And
I think the judge, looking at just the text of what the judge says at paragraph 70, subsection 5.
yes,
Fifthly, the position is, in my judgment, very different from that in Cherry Tree, in that the leases in the present case, in contrast to the facility letter in the latter case, would not, as I see it, for the purposes of Lewis and L.J.'s analysis, have been regarded as private documents, not available to those subsequently dealing with the freehold titles, but would be just as public on the registrar, on the register maintained by the HM Land Registry. Now, I thought I understood you to be saying that these are private documents, the leases.
no. So my submission is that they are not private under this
Right, I
analysis.
misheard you.
So what the judge also said at 69 is that this is a rather different analysis. What Lord Justice Lewison was considering at paragraph 32 of 30 of the judgment, which stopped at 59 and page 60 of the bundle. But in particular, if I could take you to the top part, A to B, of page 60, which was divided from a front, where we have the analysis of what is a private document in this context.
Okay.
Now again, what I say that the analysis of territory is that when a document has by the parties to the contract been purposely withheld as a private document, there's a choice not to make it public, then that would be a private document for this analysis. The leases, for the reasons given by the judge, are very different. They would always need to be registered because they were interested in land, and one would make a reasonable assumption for more than 7 years, considering they were in relation to leasehold properties in the estate. They would not, in my submission, therefore, as the judge rightly held, be private documents for the purposes of the analysis in Cherry Tree. So therefore, the judge rightly distinguished that case at paragraph 7, little 5, and he was right to hold that these documents would be.
But not my view, but isn't the point in Cherry Tree about the document being public is that it's public at the time that the contract you're construing was made, so that somebody, before they signed on the dotted line of the contract, could Google and go to the land registry and see it.
Well, in my submission, that is more than Lord Justice Lewison is saying.
Have I got that wrong?
So in the context of Cherry Tree, that is the ratio, but it's not said by Lord Justice Lewison that that is how one would distinguish between a private and a public document.
But what's the point in this case of distinguishing between a public and a private document? These leases, once they're made and registered, will be public documents. We're concerned with whether they were at the date in whatever date it is in October, or it's January, isn't it? Whenever the transfers were made, whether they were public documents then.
Well, I say that is reading more into Lord Justice Lewison's analysis, as we can see at the top of page 60, whereas whether or not a reasonable reader would have understood that the parties had a choice about what they put into the public domain and what they kept private. That they would conclude that matters that the parties chose to keep private would not influence the part of the bargain which they chosen to make public. Here, we have transfers which are registered in land registry. They refer specifically to leases. They refer specifically to 106 agreements which are public. Therefore, I say that territory is, as the judge found, a very different scenario where we do not have to have the same care in construing them without reference to documents which have not yet been registered. So I say, for that reason, the judge was right to distinguish territory on the facts of this case. Because we can see on the face of the document, the transfer itself, all the references to leases. We have the 106 agreements. Anyone considering this transfer could make the reasonable assumption that there are leases which affect the transfer, Now, whether or not they were at that moment in time publicly available, I say it's not the same as considering whether the parties have chosen not to make them publicly available, which is the analysis in Cherry Tree.
But, Ms. Mason, it could be said that as at the date that the transfers were executed, those which were executed before the leases, put it that way, that the parties had chosen to make sure that the details of the leases were private, because those documents hadn't been executed, therefore they hadn't been registered, therefore we're not talking about two documents on the register. At that stage, they have chosen to keep them private because they could have included a model lease, for example, in the schedule to the transfer, and they chose not to. So it might be said, might it, therefore, that they had chosen to keep those details private at that time?
Yes, I think there is force in a solution to that effect. However, I said it is not the correct analysis in circumstances when, on the transfers themselves, on the face of the transfers, we know they're going to be executed in respect of other parts of the development. So it wasn't in the gift of the transferee, the transferor at that point to publish those documents or register them. I say it's a very different scenario as a decision to keep a document private. So I say that they're very different scenarios.
Okay.
And therefore I say that the judge was right to find that we don't need to have the restrictive analysis of Cherry Tree. However, for the same reasons that my learned friend said, I don't think anything turns on this for the purposes of this appeal. That's not to say that you do not need to determine it, because this is before you, but for the purposes of analysing the construction of these documents, it matters not in my submission whether or not you have regard to the terms of the leases or just their mere existence, which of course we can see on the face of the transfers themselves. And also, of course, looking at the provisions that we have looked at, and we'll look at in more detail on the ground too.
So just to be clear, you're saying, anyhow, it doesn't matter whether or not you take into account the precise details of the leases, the references in the transfer to the leases shine enough light within the four corners of the transfers for your purposes. That's
Indeed.
what you say.
Indeed.
Okay.
We'll see that is also how the judge approached it on the ground too, when we are considering the transfer and the provisions themselves.
So that's your case on ground one.
Yes, correct. So turning to ground two, which I intend to approach in the same way as my skeleton, which is a two-step analysis. One, considering the transfers in isolation without reference to the leases, because I say that the judge was right to find that you do not need access to the leases in order to come to the construction, as he found that there is no unconditional right on part of the appellant to maintain and recover the cost from either the freeholder or the leaseholders in respect of the school buildings. I will then, in case I am right on ground one, and you agree with me, I will then say how I say the leases put it beyond doubt that that can't be the intention of the transfers. But I say I don't need the leases for that purpose. In any event, as you will note from my skeleton ground 3, I say the leases are important when we're considering your discretion in any event, because you will, in my submission, be driving coach and horses through all the service provisions and the carefully calibrated rent charges and service provisions in respect of this estate as a whole, were you to make the declaration sought. But I will return to that when we're looking at ground 3. So, again, if I may start with some high-level points on ground 2, which is that very heavily reliance is placed upon the 106 agreement and paragraph 5.5. Now, I will come to submissions as I say that the 106 agreement is not a prescriptive document, and that the judge was right to find that the 106 agreement cannot determine the construction of the transfer. It is admissible background for the purposes of the factual matrix, but it cannot by itself create obligations and liabilities which in my submission is the way that the appellant is seeking to put its case in many ways. Because what we can see is that by the time the transfers were granted or were executed, a much more nuanced and comprehensive mechanism in order to ensure compliance with the license agreement had been set up, which relates to, for the transfers, we have two separate companies, we have two separate rent charges, we have different provisions relating to the proportions payable under those rent charges. So against that background, the company's invitation to be granted an unconditional declaration as to its entitlement to maintain the structural exterior of these buildings is not one which is supported by the transfer document. There is no unconditional right when they are construed, I say correctly, for the reasons given by the judge. So then turning to the transfers, and without any reference to the leases, looking at the provisions. As found by the judge in paragraph 77, the company with the responsibility under the terms of this transfer for the school buildings is the Freehold Management Company. It is not the company. We see this by looking at, first, just glancing at it, because we looked at it before, the definition of retained part, which is on page 110, where of course we know that we're looking at the development, but carving out from that any part of the development that has been sold off, either on a freehold or leasehold basis.
What are you, which part of page 110 are you?
So it's the definition of retained part that we have looked at before. So we just need to keep...
This is the supplemental one?
Yes, the supplemental transfer. So we might take us through the provisions in the transfer that I say establish and that the judge was right. That it is not an unconditional right on part of the appellant to undertake works in school buildings. So we were looking at part 11, which says that the covenants on part of the company. We are looking at, the leasehold the freehold management company. We need to keep in mind what the retained part is, and as I said, that's page 110. And we know we're looking at the development, carving out any part of that development which has been sold off, either as a freehold or as a leasehold. So we know it's common ground between us that we include in that school buildings.
So, Mr. Allison's submission is that retained parts includes the walls, the roof, and the face of the old school buildings.
I agree with that.
You agree with that?
I agree with that, yes. So we then look at which company has the obligation to maintain that retained part in school buildings. If I could take you to page 124 of the transfer. We have part 11, which says that the covenant by the management company, by my client. And we can see, and I'll take us through it, paragraph 2, 4, 5, 7a and 8, that we have various obligations, express obligations, to maintain the retained part which fall upon the leasehold, the freehold management company, not the company itself. Paragraph 2, an express obligation to keep in good stand to repair, reinstate, replace, renew, maintain, and decorate the retained part. Express obligation. Then paragraph 4, to protect and maintain in a manner befitting the features, any original features in the development which is within the retained part, whether or not such a feature is listed. Again, I say an express obligation. 5, to keep in good order as the management company may think fit the grounds of the retained part in accordance with the requirements of the local planning authority and any planning agreement, including but not limited to the Section 106 agreement, insofar as applicable thereto. That, in my submission, in light of what we will look at, which is paragraph 8, must be in respect of the grounds as specific obligation in paragraph 8. But before we go there, if I could take it to 7a, which we didn't look at with my learned friends, 7a is an obligation to keep the retained part and the chattel insured with an insurance office and underwritings through any agency, and we'll see that that is to be the sole names of the transferor and of the management company. So not the company. And over the page, paragraph 8, again, express obligation to comply, not generally, but to comply with the conditions of the Section 106 agreement and any other planning agreement or any planning consent with respect to development so far as it relates to the retained part. So again, I say a very specific obligation.
So just going back to 7a, your submission is that that means that the freehold management company has an obligation to keep the retained parts, including the old school building, insured.
Yes, on the terms of this transfer, yes.
Is that, well, I can't ask if that's what happens, but that's what you told me.
I'm afraid I do not know if that is what happens. But this is where the leases come in, because we have the overlap of the obligations, but we're only looking at the transfers here. So if this is all we're looking at, we can see that we have express obligations which fall upon the freehold management company. And in my submission, they're very clear obligations. Now we then look at, because I say this is why we don't have overlapping obligations without hierarchy between them, and why we have primary and secondary obligations. We then look at recovery of these costs. If we go back to page 110, we can see that the service charge, variable rent charge, which is paragraph 19 at the bottom of page 110, is a contribution equal to, and then over to page 111, the transferee's proportion of the expenditure related to clause 2 of part 2 and part 10 and part 1 and part 15. Before we look at that, if we look at the transferee's proportion, again, as we have noted, we have the different proportions depending upon who undertakes the works, but also where the works are undertaken. So we have a clear distinction between works undertaken in respect of the estate, where it's the square footage of the property as it bears against the total square footage of all properties in the face. The face, of course, then relates back to, it depended on when the different phases of the project were completed. But by the time now, page 110, of course, it would be the entirety of the estate, i.e. the freehold estate. And then, when work is undertaken in respect of the development, is the square footage of the property in respect of the development from time to time as a whole. And we contrast that with what is being sought in these proceedings, which is in respect of the maintenance contributions, variable rent charge, where the calculation is different. It is a division, a flat division between the 85 properties on the development. So there are different provisions depending on who undertakes the works. We then look at what costs fall within the definition.
I'm sorry, you say it depending on who undertakes the works, but we don't get that, do we, from these provisions? We would only arrive at that conclusion from where you're going now.
No, so we can see that depending on the definition. So the maintenance contribution variable rent charge, which is the secondly, which is the flat 85th of the properties on the development.
Yes.
We know that the rent charge for the maintenance contribution variable rent charge is a rent charge which belongs to the company and not to the freehold management company.
Thank you.
If we then look at, to make good, what falls within the, what I would call the service charge, rent charge, we go to page 123, see that we have the fixed rent charge, which is £1, and then in paragraph 2, it is an obligation to pay towards the service charge, variable rent charge to the management company, again equal to the transferee's proportion. And then again we have the reference to expenditure relating to part 1 of part 15. That's page 134. And there we have the service charge expenditure and the definitions of what falls within. We can see it's in pursuant to the freehold management company's obligations, performance of their obligations under this transfer. And an important note that we will return to, as found by the judge, is in paragraph 2, is that when or if there is a default by the management company in this transfer, then it is the transferor which steps in with an entitlement to recover with proportion and collection of those expenses and fees from the several parties liable to reimburse the management company.
Sorry, and so where do you find that? I'm on page 134.
134 is sub-paragraph 2. Paragraph
So,
1, sub-paragraph 2.
Paragraph 1, subparagraph 2.
Yes, indeed. So the expenditure is recoverable to the extent that it relates to performance of obligations. You see in paragraph 1, and we then again go back and we do full circle and look at the obligations again, which we looked at page 124, and it is part 11 where we have, I say, the express obligations in respect of the retained part. So for those reasons, I say that the judge was right to find that the company, with, to use the language of our primary obligations under the terms of this transfer, to undertake the maintenance in respect of the retained part and therefore the school building, is the freehold management company. And they are not interchangeable because the different proportions of the rent charges apply depending on which company undertakes the works. So it is not a question about that these are interchangeable and overlapping and therefore it doesn't matter who does them. It does matter. And the judge was correct to find that the express obligations under this transfer force upon the freehold management company. You can see again the express part of, go to page 135. You can see, which is part of the service charge expenditure in paragraph 3. We can see the importance in this transfer on the face of the documents. That's what I say in my overarching points and my high-level points about that the intention in this transfer is that the parties pay for, in essence, their part of the development. You can see that in paragraph 3 where it says, where any part of the service charge expenditure is incurred by the management company only in relation to the estate and not any other part of the development, and such part of the service charge expenditure shall be divided between the owners of the estate in accordance with the transferee's proportion in relation to the estate. So this, in my submission, makes it clear that the intention is not that when works are undertaken to the so-called freehold estate, that the lessees are intended to pick up or any other property on other part of the development, the tab for that, but rather the transfer made it clear that what is intended is a division, that you pay for your part of the development. So I say that is a clear obligation and it falls on my client. We then contrast that with the obligations on part of the company. They are set out in part 12, starting at page 127. There we see part 12 covenants, and over to page 128, we can see what they are. Now, I will come back to and make good, I hope, the point as to why I say my learned friend is not right about his construction about the common areas being retained part. But for through these provisions and then make good why the common areas are not retained part and therefore do not relate to the school building. So here, the company's covenants relate to keep good and substantial repair, restate, replace, renew and maintain the communal facilities and the communal areas. So not the retained part. Again, the same when we're looking at paragraph 3. The covenants are expressly in respect of communal areas and communal facilities. We then have the express provision in paragraph 4 in relation to the chapel, which is obviously one of the listed buildings, but there is no reference to Yarra House or to the school. We of course have paragraph 6, which is the key provision for the purposes of the appellant's argument, which is the maintain and manage the communal areas and communal facilities in accordance with the requirement of the Section 106 agreement and comply generally with the obligations detailed in the 106 agreement. Now, I say that comply generally clearly shows in contrast to the clear obligations to comply which had been imposed upon the Freehold management company. And we can see if we continue that provision in paragraph 6, that in particular to use the chapel contributions for the chapel only as defined in the 106 agreement. So again, the emphasis on the chapel and the communal areas and communal facilities. And for the avoidance of doubt, the chapel contribution shall first be used by the company to comply with the provision of clause 4 of in relation to the chapel. And thereafter, the maintenance of chapels shall be part of the maintenance contribution variable rent charge in the clause 4 above. As the comments that the finding of the judge is, if that had intended to include the other listed buildings, one would have expected paragraph 6 to say so, because it expressly says so in relation to the chapel. So if that had been intended to be a catch-all with the intention that the company would be maintaining all of the listed buildings on site, then surely he would have said as much in paragraph 6, but it's referring to the chapel, because we have it for avoidance of doubt here. Again, if we're looking at paragraph 7.
Just pausing there, you made some short time ago the distinction between the communal areas and the retained parts, and you say that the communal areas, as defined, does not include the retained parts. I'm trying to think, Mr. Allison's case is the other way around. If Mr. Allison is right in that submission, why so the communal areas do include the structure of the building, what difference there would be between the communal areas and the retained parts? I can't think of anything else that would not be a retained part.
No, so my submission when we look at the communal areas is that they are carved out, these are specific. This is where we have the general obligations and the specific obligations.
So the communal areas are defined as the land, and Mr. Allison says the land includes the walls and the face of the building, any land on the development which serves the dwelling units on the development not included or intended to be included in the sale.
Should I come back to the remainder provisions in part 12?
Well, I'm catching up on your previous submission, but that's very important.
It is very important, absolutely.
Why, if the communal areas include the building, the old school building, its structure, its face, etc., why it's necessary to make a distinction between retained parts and communal areas? Because these provisions here in part 12, as you've shown us, limit the responsibility of the company to the communal areas and not the retained parts in the sections you've taken us through.
Indeed, and I say the distinction is very clear when we look at the definitions that I will come to, is that the communal areas have a very specific part of being part of development, which is used by all of the units communally. Now, the freehold or the buildings, the school buildings, there's no access rights at all to the leasehold companies. And I'll make good that submission by looking at the covenant and the transfer. They have no right to enter it. They have no right to any.
No, but that's a different point. But I think I've made my observation.
Yes, I'll come back and I'll make that point. But if, for the purposes of this, and I'm taking you through the covenants, if you should maybe on my submission that communal areas do not include, it's not a catch-all to include the communal part and buildings, but they are exactly what they say, areas communal to all of the units on the development, then we can see that what the companies intend to do is a much more narrow remit, the very specific obligations in respect of the communal areas, the communal facilities, the communal services.
Thank you.
And as the judge stated, if the intention was to include in that, as we have included chapel specifically, the intention was also to include in that the structure of the school buildings, then clearly one would expect these covenants to say so. When the covenants in respect of the freehold management companies are so clear, why would you read that in to this general obligations, the catch-all in paragraph 6? Over the page, just to finish my submissions on these provisions, paragraph 10 again, it deals with an obligation to insure, but it is limited to the communal areas and the communal facilities. So what that would mean is, if the company proceeded to insure the school buildings, because they were going to undertake some works to it, there would be no right to recover any of the cost in respect to that under this transfer. Again, another part of this transfer militates against the construction given to it by the applicants. You can't recover the cost of insurance. So, then making good my submission that the communal areas are what they sound like they are, and does not include the school building and the retained part. If we look at page 109, and the definition of communal area, communal facilities, and communal services, I say, first of all, the fact that they are communal means that they are intended to serve all of the units, the freehold and the leasehold units. I say this is made good when we're looking at the definitions. So communal areas means any land on the development which serves the dwelling units on the development. So there must be a benefit. It must serve the dwelling units.
And it doesn't say all of the dwelling units.
It doesn't say all the dwelling units, but I say that the dwelling units, without carving them out as being the freehold, the leasehold, and we are talking about communal services, must on their true construction relate to services and areas which relate to all of the units on the development, because we know that there's a freehold and a leasehold part of it. My submission, that stems, if we also look, it's more support if we look at communal facilities, means the state roads, the service installations, street lights and furniture and other facilities within the communal areas, which serves, again, the properties in the development. It is not a reference specifically to only some of the properties. But the point is even more, is better made by reference to paragraph 5 of the communal services, where it says, means those services, if any, provided after for the benefit of development from time to time, for the joint benefit of all residents and occupiers of the development. So, construed together, holistically, the common areas, the common facilities, and the common services, I say, must relate to matters on the true construction, because otherwise they would be odious if they form part of the retained estate, unless they intended to be for the communal use of this development as a whole. So, in my submission, therefore, any part of the development which exclusively serves some units only could not be communal areas. So, we then look at, can you say that the school buildings serve in any way the freehold estate? And I say, no, you can't. When we look at the rights granted to the property, which which we can find at page 115 and part 6. My learned friend took you to paragraph 1, which is the right of way in common with the transfer law and all other entitled to the like right over and along the state roads and communal areas, divides and paths, entrances, hallways, passages, stairways, and here I say are the relevant words, giving access to the property. So I say that any right of way is limited. It's not a right to roam around the development. It is a right to access the property, whichever one that is being transferred as freehold property. This is not a general right. It certainly does not give the freehold owners any right to go into the school buildings. And the rest of part 6 does not contain any other rights on part of the freeholder to access any part of the school building, to do anything with the school buildings. They are exclusively for the benefit of the freeholders. So against that background, I say they cannot fall within the definition on the natural reading of communal areas because they're not communal. They are squarely falling within retained parts.
Yes, there must be communal areas inside the school building. There must be corridors, are there, between the apartments?
There will be communal areas for the leaseholders, but as we can see from
Yes.
part 6, the freeholders have no rights.
They've got no right of access, but it doesn't mean they're not communal areas.
It does mean they're not communal areas for the purpose of this transfer, because
Does
they do
it?
not serve,
The communal areas means any land on the development.
which serves the dwelling units. So
Yes.
I say that
Which
part of
serves,
land-
you say serves all the dwelling units.
Yes, indeed. So I say that this transfer, the communal areas, are not relating to any part of the development as
So
a whole.
you say in each transfer of freehold, where it says communal areas, it means communal areas on the estate and not communal areas in the old school building.
Well, I say the communal areas is limited to any part of the development which all units on the development can enjoy. The estate roads, for example, where they all have a right of access.
Yeah.
The plan seems to suggest there's a path that goes around to the estuary. There might be some, I don't think there are any car parking spaces, but there'll be some green areas. There'll be some bushes and shrubs that are seen from photographs. That is communal areas. What is not a communal area is the inside of the school buildings or the facade of the school buildings or the roof of the school buildings, because they don't serve any other purpose than the leasehold flats. They don't serve the freehold transfers. And I say that that is the true construction of the communal areas, because we have, although we don't have other than communal services, a reference to all residents and all occupiers on the development. I say that the fact that we have that wording is indicative of what is intended with communal, but the primary word is it needs to serve those dwelling units. It needs to be some kind of utility for those units for it to be a communal area. And I say that is because also the word communal means it is for everyone's benefit, not just some.
Okay.
So for those reasons, I say what we have is a clear distinction between different obligations in respect of the estate. We have the company, the appellant, who has an obligation in respect of the communal areas to ensure, to maintain, keep in good repair. We have the freehold management company with obligations in respect of all of the retained property with an obligation to repair. On the wording of this transfer, that will include the school buildings. I say those covenants are very clear and they have different provisions in respect of the percentages or rather charges which attaches to the rent charges. They are not interchangeable. They must have a hierarchy because, as the judges rightly found, they cannot be an objective intention of the drafters or the parties that it depends on who came running first with the tools to mend. That cannot have been intention. And when we have clear and specific obligations on part of the freehold management company, and potential residual obligations only on part of the company, there must be a primary and a secondary obligation. Now, I agree with my learned friend, there will be a patchwork of Section 106 obligations attaching to various different owners of interests throughout development. You will see when you look at your house, it also attaches to the individual freeholders and also the different companies. But that, in my submission, is not sufficient to construe this transfer to mean that the company has an absolute entitlement to assume responsibility of a part of the estate which the freeholders have absolutely zero access to, no rights in respect of, and maintain it at their whim. I said that is not how these transfers can be construed. When we go back again and look at what has to be relied upon by the company to make that submission, it is an incredibly vague and general obligation to generally comply with the 106 agreement. When we look at that again against the recital at page 112, I say we can see the intention here. We have, I think we go to this, secondarily, a residual right or obligations. 112, forgive me, which is paragraph 5 of part 3 of the recital. Where the company has agreed to join this transfer with responsibilities for services, repairs, maintenance, insurance and management of the communal areas and community facilities, and to ensure that the obligations contained in the 106 agreement are performed as opposed to performing them themselves. There might be some step-in rights at some point when there has been a default and other parties or interested parties with rights and obligations on this development has failed in their primary obligations. But I say that does not give rise to an absolute entitlement to maintain. Now, the judge also found that paragraph 78, that the suggestion that the liability was on an unconditional right to maintain all of the listed buildings is a curious one when you consider it in the context of Darragh House or 8 George Drive. As found by the judge, and it's coming around, I think, the transfers of Darragh House are identical. And we can see that the obligation to repair in respect to Darragh House falls upon the freehold owner. It's him or herself. This is page 120 of the part 10, which are the positive covenants by the transferee, where it covenants with the transferor and the management. So paragraph 3 and 5, we have primary obligations, I say, to keep the property in good and tenable repairs. 5, to do so by protecting and maintaining in manner befitting to the features and any original features in the property, whether listed or not. Again, that would be an obligation on the owner to comply with any listed features. Now, we then have the obligations, or the rights rather, to step in. As noted by my learned friend, the only right on part of the company and all the covenantees. The covenantees, as we looked at before, includes all the lessees in the development under section 56, is to go in to inspect and to examine and repair and make good any defects or want to repair. No obligation to recover those costs if decided to undertake the works. Rather, that right falls on paragraph 9. The obligation if there's been a breach falls upon the management company or the transferor, which has a right to enter the property and to recover those costs. As noted by the judge, this would be a very curious setup if the company was right and it had the obligation to maintain Darrow House. Now we can see that the drafters of these transfers had in mind that there were different properties as part of the freehold transfers. For example, we can see at page 116 that plot 74 was going to be treated slightly differently. It's going to be a right of access over some land coloured purple. At 117, plot 73 and plot 77, 78 and 88 were to be treated slightly differently because there was an air raid shelter, which also is a listed, it's a protected feature. So those properties were to be treated slightly differently on these standard transfers. Again, page 119, we see slightly different treatment of 77, 78 and 88. But we don't have that for Darrow House. Again, as noted by the judge, that would be curious if the company's construction was correct and that it has an absolute entitlement to go in to Darrow House, undertake works, and then charge all of the freeholders and all of the leaseholders a proportion of those works. That makes little sense. Now, my learned friend says in his an argument that there's no need for the company to have any access rights in respect to Darrow House because it has an entitlement to maintain. Well, in my submission, that's a circular argument because it depends upon the construction of paragraph 6 to start with. So if he's not right on paragraph 6 and Darrow House part 10 in respect to Darrow House militants against that construction, then I say the judge was right for the reasons he gave to say that on the true construction and taking that into account, that can't have been the intention. Now, page 80, 117, which sets out the findings in respect of Darrow House and little 1. He says, firstly, if the company's right...
No, I'm sorry, I'm in the wrong place.
Oh, forgive me. I just rushed into that reading.
Page 117.
Page 117 of the before bundle, which is the judgment.
Right.
And I was just reading out because I can't put it as well as the learned judge.
Paragraph.
It's little 1, paragraph 84. The top of page 117.
Thank you.
Where it says the company's rights, that would mean that if Darrow House or the interior part of the mice apartments fell into disrepair, the company would be obliged, without more, to repair them, with an ability to recover the cost, therefore, against all the leasehold owners and freehold owners, despite the fact that the owner of Darrow House and the relevant leasehold owners had assumed responsibility for the repairs, and the right to step in if there was a breach was reserved to the developer and the freehold management company, and the leasehold management company is appropriate, and specifically not the company. That would make little sense. That brings me to another point which has been made. That's in paragraph 33, page 36 of my letter friend's an argument that there is nothing in this transfer which prevents the company from going in and undertaking works to the school building. And I said that, again, that isn't right, because when we look at access rights of the company, it hasn't got an absolute entitlement to enter any part of the development. We go to page 131 of the transfer. And paragraph 7, which is part 13, covenants by the transferor, which is transferor.
Sorry, I missed it. What page number?
It's page 131 of the transfer, which is the supplemental bundle. governance by the transferor with the management company and the transferee. And we see at paragraph 7 that the management company, the person authorised by the management company and the company may have access to the development and any part necessary or proper to enable the management company and the company to carry out their obligations contained in the transfer. So unless my learned friends can satisfy you that there is an obligation on part of the company to undertake general maintenance works to the school buildings, then there is otherwise no right of access. There is no general right for the company to go upon any other part. Likewise, I say, well, in respect of the entitlement to recover costs, if we look at page 136, the maintenance contribution expenditure, I say, is contingent upon the company carrying out its obligations under the transfer, under the true construction. There is no absolute entitlement to undertake anything that the company sees fit and charges under the rent charge. All of the payment provisions in part 2, paragraph 1 onwards are in respect of carrying out obligations of the company under the transfer. So again, it becomes that circular argument. So I say that it isn't right that there is nothing preventing the company. It needs first to establish its right under paragraph 6 that we looked at to undertake works. And again, I come back to the high-level point that I made. This is not a case where there's any suggestion that the 106 agreement has not been complied with. This is not a position where there is any evidence that the buildings are in disrepair and require maintenance for the purposes of compliance with the 106 agreement. Finally, the judge also took into account various background facts he found were relevant at page 115, paragraph 79. And I say he was right to do that for the reasons that he gave. So again, assuming that the leases are not part of the relevant admissible background, this is paragraph 79 and page 115, the judgment. The parties to transfers would know, not least from reading section 106 agreement, that the leases were being granted on terms that broadly mirrored the transfers, and that demises of apartments within the school buildings were likely, in accordance with leasehold conversing practice, to have excluded the structure exterior of the school buildings, which would thus fall within the definition of retained part, for which an equivalent, the freehold, to the freehold management company, the leasehold management company, in fact, the LMC, would be responsible for repairs. Further the extent that it would have been anticipated the leases would replicate the transfers, it would be reasonable to have anticipated there would have been a leasehold management company, LMC, with obligations so far as compliance with Section 1 agreement was concerned, replicated under those of the FMC and the transfers. So again, facts, background facts, which the judge found does not support a construction contended for by the company. So considering the factual matrix and what I say are carefully calibrated service charge provisions where expressly on the transfers, the intention is that the parties pay for their part of the estate and development. The company is not entitled just to decide upon its own volition to undertake works which fall within someone else's preparing obligations, when the consequence of doing that, with different charging provisions, apply in this case. And as the judge said, it cannot depend upon who gets there first, of how these, who pays the costs, and at what proportion. So, addressing some of the points in my learned friends gave an argument that there is an immutable division of obligations and that there's no reason to attempt to avoid this overlap. I say, well, on the natural reading of the transfers, yes, there may in certain circumstances be an overlap, but they do not need to be construed, and the natural reading of them do not result in overlap, which allows the company to go in and maintain the structure of the school buildings. It doesn't depend on who gets there first. For the reasons that I set out, the judge was right to find that the primary obligation falls upon the freehold management company. You can avoid this overlap. It's not an invariable construction. Actually, it is creating ambiguity the way that my learned friend is construing, particularly the communal areas. I say the natural reading is communal areas are exactly what they say. Communal. All of the part of the property, not matters, not part, which exclusively serve leaseholders. So they're not interchangeable, and therefore they can be construed the way the judge found them to be. Now, there are two other points. The one is in paragraph 41. It said that this is a fair basis.
Of the judgment.
No, this my learned friends gave an argument. Paragraph 41 so says this is a fair basis that everyone pays equal, that it makes sense. Well, I say that on many levels it's not really relevant because it's not how we construe documents. It's not about fairness, it's not how to buy a bargain. But also, when we take into account their house, no one is contending on part of the appellant company that it is intending to go in and undertake works to that part of the listed buildings. So I say that submission that just doesn't withstand scrutiny. And the final point is addressing the heavy reliance on the 106 agreement. And for the reasons set out in paragraph 77 of the judgment, the judge found that the 106 agreement cannot be determinative of how to construe the transfers. And I say that is absolutely right. The 106 agreements do not, by themselves, impose an obligation on the company. It's not a party to the 106 agreement. We know that the mechanism is much more nuanced because a few months after the 106 agreement, we had 3 companies set up. So the 106 agreement in my submission cannot be the starting point of the construction of the transfers. We need to look at the transfers themselves. And they do not support the construction intended for. So, for those reasons, I say, looking only at the transfers and nothing at the leases, we get to the same position as the judge, as he said. Nothing turns on the leases. But
Can I just ask, the point you made about the company having no obligation to carry out repairs, and that they're only entitled to enter the properties if they are discharging an obligation that they have. Is that a point that was raised with the judge? Is it covered in the judgment, or is it?
It's not covered in the judgment,
No.
but yes, these submissions are the same
Right.
As they were in the court below.
So this is therefore an additional ground that you said the judge should be upheld on.
Well, I say it is part of construing the transfers as a whole. I don't say it on itself, by itself, is the
You said it's all
outcome.
it's all part of a piece.
It's all
with your
part
case.
of looking at holistically at all
Yeah.
the
No,
transfers.
I just spent a bit of time trying to find out where the judge dealt with that. And
No,
he
it
doesn't,
wasn't.
yeah.
It wasn't. It was at the end of day 2 he gave judgment explorer,
very impressive.
and he didn't. Yes, indeed. And because I wasn't counsel, I stepped in last minute because of the bereavement of my colleague in Chambers. So I was only instructed on the Friday. So it wasn't. He didn't have the benefit of my written skeleton.
Right.
So he had to take some careful notes as I was speaking.
Right.
So that might have just been the reason why it
Well,
wasn't.
it doesn't matter. I just if it was a known, if it was something the judge had dealt with, I'd wanted to see what he said.
What he said.
Thank you.
No, it's not the judgment. So then, looking at if I'm right on judgment right on ground 1, and we can consider the leases, I say what they do is put beyond doubt that it cannot have been intention that the company would step in and take charge of the maintenance of the buildings. I say that because, again, the judge was correct to find that under the terms of the leases, the leasehold management company, not the company, is responsible for the repair of the structure of the school buildings. We find that if we look at the supplemental bundle, page 77, where we got the lease. So, clause 8 of the lease sets out the management company's, the leasehold management company's covenants with the tenant and the landlord. We again see that it replicates 8.2. We have the obligation to repair the retained part, which we all agree includes the exterior and the structure of the school buildings. 8.8 at page 78 of the page, at the bottom, we have an obligation to protect the manner fitting to the features that replicates the original features of the development, which is within the retained part, whether listed or not. 8.11, which is page 80. And same as we have in respect of the freehold management company to comply with the conditions of Section 106 agreement, any other planning agreement, and any planning consent with respect to the development so far as it relates to the retained part. Now, again, when we look at who has got the right to step in, if there are any failings on part of the freehold management, leasehold management company, we see at 8.14 the obligations again falls upon the landlord, and the important is that the landlord then gets the right to recover the service charge in the obligations on part of the tenants to pay. So when you step in, again, the defined provisions of how much the payment will be falls upon the freeholder and not any other percentage or proportion. So again, when we have the leasehold management company and the freehold company, I say have primary obligations in respect of the 106 agreement and the retaining part. This is also supported when we're looking at, for example, clause 17.15 and 75. Which contains, clause 7 is an obligation on part of the tenant. We can find it at clause 7, beginning of clause 7 to page 71. The tenant covenant with the landlord, the management company, the company, and separately with each and every tenant and owner for the time being on other properties in the development. So again, obligations enforceable by all the freehold owners in section 56. On the clause 7.15 and 75, again we see an obligation part of the tenant, the covenant, not to do or omit to do or permit to suffer to be done or omit to be done anything in the property, in essence, which contravenes the section 106 agreement. And indemnify, this is important, the last 3 lines, and 2, indemnify the management company and the landlord against all action, proceedings, costs, claims, and demands in respect of those acts and admissions. So again, support a construction of these leases that the obligation, the primary obligation to comply with the 106 agreement falls upon the management company and the landlord, and not the company. We see the same outcome if we construe clause over the page 76, clause 17.24. Again, it is if the management company or the company company fails to perform its obligations, and the landlord, by reason of the request of the tenant or the owners of other property on the development, is required to perform those obligations to make payment in respect of the performance of those obligations in advance on demand to the landlord on the amount equal to the service charge or the maintenance contributions applicable. So again, the step-in rights revert back to the freeholder and not the company. And again, the service charge and maintenance contributions remain the same, they don't vary. Now, a further reason, of course, as set out by the judge, is that when we're looking at how the service charges are divided between the estates, we know that there are two estates. When we look at those plans, we have two different buildings. And when we are looking at the tenant's proportion at page 66, we see the importance of the estate. And we can see that as in the transfer, we have very clear obligations relating to where the property is in respect of the estate, the development, but also within the estate itself, i.e. within the school building. So firstly, we have the proportion of, in respect of the expenditure of the estate, which is the square footage of the property, in respect of the estate, and the square footage in respect of the development. Then thirdly, the equal proportion of expenditure between all the properties in the development. But fourthly, and very interesting, again, I say supporting the construction, that what we're looking at here are really an obligation to pay for your part of your estate, or your part of the buildings, where the property is accessed via internal communal areas within the estate. Thirdly, so far as such expenditure relates to the internal communal part, that proportion of expenditure with square footage of the property bears to the total square footage of all properties which are accessed via internal communal areas, a fair proportion of the internal communal part costs. So again, it is again a smaller area, depending on where the costs are incurred and what they relate to. Again, supporting a construction that here we have transfers and leases that are very focused on ensuring that you pay for your part and not other part of the building. Again, I say militating against the construction, that a company is entitled as a matter of course to go on to a part of the development which the freeholders have no access to and undertake expensive works to a listed building. So again, these are obligations which are not interchangeable in the lease, same as in the transfers. We then look at the company's covenants in clause 9 at page 82. So the maintenance contribution, or the estate service charge, as you may have referred to it, is normally known as, in respect of the company.
But where are you on 82?
Page 82, so
yes.
that is paragraph 9, so that is a G, subject to maintenance contributions being paid by the tenant.
I'm sorry,
I can't see a G on
81.
It's just in the middle of the page between the two holes, just above a 9.1. And we start
91, I was on
company's
92.
covenants.
81. Yeah.
Again, we replicate the transfers, and we can see that communal area, that the company's obligations here again is in respect of the communal areas, the communal facilities. 9.4 is the replica of the covenant which is being relied upon in the transfer, and one would assume that on the company's construction, this covenant must be in exactly the same thing in the leases as it does in the transfer, as it says in little c, to maintain and manage the communal areas, the communal facilities, and then turning to page 82, in accordance with the requirements of Section 1 agreement, and to comply generally with the obligations detailed in Section 1 agreement, Section 106 agreement, and in particular to use chapel contributions to the chapel, etc. So this is the mirror provision. In my submission, when we consider that in this context of the lease, and again we consider the service charge provisions, and the proportions of the service charges, it is, in my estimation, not correct to construe 9.4 in a manner where the company could step in and undertake works to other parts of other buildings and recover from the leaseholder. But
you're going to leave yourself sufficient time to deal with ground 3.
yes, I am.
We have to finish today.
You speak much more than I ever anticipate. Yes. So I say, considering those provisions, it is very clear, and considering again, when we come back to the discretion point that I will address you on very shortly, on the company's own construction, and one wonders why they haven't also asked for a declaration in respect of the right of the company to recover from the lessees under clause 9.4c the company's shortfall, and the answer must be because they would fail on that in the FTT, surely, because all the leaseholders would say, well, hold on 1 second, why am I now being responsible for the other school building, which does not form part of my estate? I'm only responsible for my estate, and I shouldn't have to pick up an estate service charge in respect of listed buildings elsewhere, because that is not how my lease should be construed. And again, I say that militants against the construction of the same provisions in a transfer can't have been the intention. So, construing these provisions, again, I say cannot have been the intention, that they don't fit together, that they're not construed in a coherent manner to reflect each other, and the fact that these are a large development with 85 individual transfers, they must be construed holistically and together, I say, and for the reasons set out by the judge, they do not allow for the company to step into other companies' domains and take over at their whim in order to reduce liabilities for some of the occupiers of the estate or the development to the detriment of others. And that brings me very neatly to my third ground and discretion point. As you noted from the judgment, the judge did not, page 8, paragraph 89, 88 and 89, he did not decide a point, but as I noted my little friend, he indicated that he wouldn't have been with me on that, or notwithstanding the fact that he has reservations about making declarations affecting the development, where not all parties are party to the proceedings. Now, I say that this is a case where the court should not exercise, even if I'm wrong, and the company has a right to maintain and to recover against the freehold owners under the rent charge the cost of maintaining, as a matter of course, their building. I say this is not a case where it would be proper to grant a declaration, considering all the parties who are not represented and have taken no part in these proceedings. You cannot be satisfied that you know that their side of the story or their part of the proper analysis of their cases is before this court. Now, I say particularly important is the fact that Gray, who is the freehold owner of this company, is not a party to the proceedings. Now, the company is in effect, under the terms of the lease, is seeking to take over the management of the retained part of the freehold of Gray's. There is no reason at all, if Gray was content with that outcome, that Gray has not been notified of these proceedings, is not named as a party to be bound by these proceedings. There is no evidence that Gray even know about these proceedings. Now, if Gray would not object to the company taking over, in essence, the obligations it has entrusted, or as predecessors entitled, has entrusted in the leasehold management company, one would expect to have had that confirmed in evidence, if so in a letter But we have nothing. There's nothing before the court below, and there's nothing before you now to indicate that Gray is content for that to happen. In my submission, it cannot just be assumed that Gray is content in circumstances when, again, there are no absolute entitlements on part of the company to enter the retained parts. There is, for example, obligations to insure the retained part on part of the leasehold management company. There are no obligations to insure on part of the company. We have no confirmation that the insurance wouldn't be affected. There are so many potential arguments as to why Gray, as the freehold owner and the registered legal owner of this land, does not want a third party entering to undertake works which it has entrusted another party. And there is no benefit to it, because the leasehold management company has covenanted with all of the leaseholders to recover 100% of those charges. Gray is not going to benefit from a third party entering and undertaking the works and charging other people. So, for that reason, I say this is a case where a declaration should not be sought. Turning then to the leasehold owners, which is very curious.
Sorry, turning to the
leasehold owners, who are not a party, but are the controlling minds of the company. It is set out in both witness statements of Mr. Jones, so the first and the second ones, that he is authorised to give undertakings on part of the leaseholders that they will comply with the outcome of this case. Now, the declaration sought, of course, when they gave that, is that they are required, or rather the company is entitled to charge them 1/85 of the cost of maintaining the school buildings. What that, of course, means is that one of the buildings will be paying for another building, which under the service charge provisions, they're not responsible for paying. When I made that point in the court below, Mr. Uff, who preceded my learned friend, Ms. Allison, in reply submissions, sought to amend the declaration which was being sought to say that actually the company no longer wants a declaration that it can recover 100% of its costs as against the freeholders and the leaseholders, which is paragraph 7 of their pleading claim. It was in reply submissions, no permission to amend the claim form was ever granted. It is noted in the judgment, I think in paragraph 8, in passing. Page 84. Now, again, it raises more questions than it answers, that there is an intention to give an undertaking to be bound. We don't know what that means. We have never got a list of leaseholders. We have requested it. There is no list of leaseholders. It's requested a trial, virtual mass skeleton. We don't know who these leaseholders are. We don't know what they mean by giving an undertaking. Is that analogous to an injunction? Are they submitting themselves to the possibility of committal proceedings if they challenge that charge in the FTT? They plainly, in circumstances when the effect of the declaration being sought affects their leasehold interests and affect their service charge provisions, should have been parties to these proceedings. And there is no answer to why they're not parties. And there's no answer to why the declaration is now not being sought in the terms that have been pleaded. If they are willing to give the undertaking, then we should have been provided with the evidence of what they're actually agreeing to be bound by. Are they varying their leases, or are they merely submitting to the fact that their lease should be construed in accordance with transfers, and therefore the company should be undertaking works to all of the listed buildings? Without those answers, this court cannot be satisfied that you have all of the arguments put before you, or with all the parties who are affected of this declaration being sought, what they consider the position to be. And when there is really just no answer to why they're not parties, again, it's another reason why this court should not grant the declaration. We then turn to the leasehold management company, They are a party. They are a company 100% controlled by the leasehold owners, who have all, in accordance with the written statements, given untaken to be bound by the outcome. But it's the leasehold management company with the primary obligations under the lease to undertake the works to the school buildings. Why don't we have a witness statement to say, yes, we agree, we will cooperate with the company, we're not going to be rushing to undertake duplicates of works. We don't have any evidence what the leasehold management company's position is. And again, there is no answer to why not. If the leasehold management company, Gray, and the lessees were all content with the outcome of these proceedings, why is there nothing before the court to confirm that? So against that background, this is not a case where it is appropriate to give the declaration sought, when there is absolutely no explanation ever being proffered. Now, finally, that goes back to the judge's decision, and the fact that he said, well, that even though there might be a residual ability on part of the company, in certain circumstances, to step in and do works, I say that it is always inappropriate to give this very narrow declaration relating to one covenant only, without construing as a whole the obligations and how they interlink and how the overlap is supposed to work. It was never appropriate to grant a declaration in these terms. The reason, of course, is because the leasehold directors of the company wanted to minimize their liability in respect of the school buildings by charging what they are responsible for under the lease as a service charge to all of the occupiers of the development, including the freeholders. But that, without construing all the documents and how they fit together, is wholly inappropriate. So I say, even if I'm wrong on the construction of these documents, this claim should fail, because the court should not entertain a declaration which is not going to resolve matters. It is not going to assist the parties in knowing how they proceed with this development. It should have been sought as a holistic declaration in respect of all the obligations, how they all fit together, with everyone being a party. It hasn't been. The suggestion by my learned friend that this matter should be sent back to the trial judge, I say, is inappropriate. The trial judge didn't hear any evidence. This is a Part 8 claim. It was all done on the same submissions I have done before you today. The trial judge would be not in a better position to make a decision on discretion or any other point. You have all the information that the trial judge had. So I say this is the case that
in exercising the discretion, the court at that stage is entitled to look at the leases. Is that right? Because we're exercising the discretion we do now in 2022.
I say you must look at for the ground 3 and whether it's appropriate to grant a declaration where you have a very wide discretion, and you always have to take a step back and consider, is this the best way of resolving the dispute? Should I exercise my discretion? You need to look at it holistically. You need to look at the transfers, how they fit together with the leasehold interest, whether we are resolving anything at all by granting the declaration, or whether, in actual fact, it is not going to assist the parties at all to move forward. And particularly in circumstances when, as I heard my learned friend before, the declaration now still continuously being sought is one relating to only half of the expenditure on part of the company, i.e. only against the freeholders, and the right to recover under the state management, so to speak, charge under the leases is no longer pursued. I say it is wholly inappropriate.
Is it a factor? If we granted the declaration as sought, so that the company is entitled to go in and do this work, is the potential for that, rather than solving anything, actually to fire the starting gun for the next round of litigation?
Indeed. Absolutely.
That it would be on the basis that the company wasn't solely the body entitled to, that at least the leasehold management company could, and on one view, your clients could, if they wanted to, go in, and then so you're into a further dispute, and so this is part of your submission, I think, about the court needing to look at the whole picture.
Indeed.
And not simply cherry pick this request for a declaration and say, yep, that's right, we'll grant that, because that may further imbalance an already distorted set of arrangements and lead, as I've indicated, to further litigation.
Indeed, and particularly as we've seen, there are various covenants that can be enforced by the freehold owners in respect of the service charge provisions against lessees. One could envisage that if it is not declared holistically how these different management companies and the different provisions are supposed to work together holistically, that you would have various different individuals and companies issuing litigation, which would then half be bound by this declaration, potentially want to go behind that on factual scenarios that you don't have before you. So yes, indeed, I say it's a recipe for more litigation and not resolving anything at all.
And do you take the point also that the declaration which is sought is very general? There's no evidence that there are any specific works which need to be done. And on that basis, it would not be appropriate to exercise the discretion.
Indeed, and this goes back to the construction of the covenant. If there is an obligation, it is an obligation to comply with the 106 agreement, and there is just no evidence before you that the 106 agreement needs complying with, that it isn't being complied with. It should have, as noted by the judge, been done in a context. Now, we do have demands. We have seen that there have been various demands. They are in the supplemental bundle for different charges, but notwithstanding that, you haven't been asked to adjudicate on a particular one of these. You've been asked for a general, yes, you can always, as a matter of course, go in and do whatever works you want, more or less. And I say that is just not appropriate. Even if on a true construction, there might be circumstances when the company could go in, but we don't know what they are.
Thank you.
Unless I can assist you any further.
No, I think you've covered the ground very thoroughly. Thank you. Yes, Mr. Allison.
Well, if I can come back very briefly on just a couple of points on grounds 1 and 2, and then I will give you my quick response to ground 3 and aim to be done by 4, but without a firm promise, but I'm going to do my best. On ground 1, just a couple of points I wanted to pick up on. There was a point about paragraph 70, small 1 of the judgment. Top of page 111.
Thank you. Yes.
And the suggestion that the fact that they were sold off contemporaneously, one with the other, is a finding of fact against which there is no appeal. I say that's a mischaracterisation of the position. Paragraph 70, or 69 and 70, sets out the reasons why the judge considers the relevant provisions of the leases can properly be said to have can't be said not to have been available to the freehold owners. The actual finding of fact on the point is the one at paragraph 25. The judge expressly finds at paragraph 25 the dates on which the instruments are entered into. So I say the respondent can't rely on paragraph 70 sub 1 as a finding of fact that contradicts paragraph 25. I mean, that doesn't work.
And he doesn't say when the leaseholds were sold off.
Paragraph 25.
And it says dealing with freehold at 25.
Paragraph 25.
Oh, the relevant leases granted were granted by the developer.
Yes.
My fault, I started the sentence.
Between the 16th of October. So
yeah.
there is a finding of fact about which there's no dispute, as to the relevant dates. And paragraph 71.
Sorry to interrupt. He does say at paragraph 25, though, after having mentioned the dates of the leases, sales of the freehold properties took place contemporaneously therewith.
Yeah.
Yes, in the sense, I mean, my reading of that is, well, they overlapped. No dispute about that. But the fundamental point about was there a freehold transfer at a point when there wasn't a leasehold transfer, that can't be seriously open to doubt in light of what it says in paragraph 25. And that's a finding of fact about which there's no dispute.
Well, he does say contemporaneously with the leaseholds, which is in terms of the sequence of events you described, that's wrong.
Yeah.
That's what the judge says.
Well, my reading of it is he took the view that it all took place together as one process, but that doesn't change the timing of the documents that's found in paragraph 25. It's really the only point I'm picking up on.
I don't think we're going to decide the whole ground hanging on to this.
No.
Those finding of fact.
To the extent that I'm required to seek permission to appeal on a finding of fact, I do so. But that was my point. There was then a point about the conveyancer asking about a copy of the lease. My friend still relies on what the judge said. Reasonable conveyancer would have asked. And the question was, well, what if they refuse? And the analogy was, well, it's similar to if you have a right to go in and look at the land and you don't, and there's an argument over the boundary. It's a physical feature. But I say if we look at paragraph 130 in Cherry Tree, that's the example expressly considered by Lord Justice Lewison and deemed to be as a different situation. That boundary point is specifically referenced.
Wait, it's a matter of common sense, isn't it? The land is there.
Its physical features are there.
Lease.
The lease isn't.
A lease is created on a particular date. And it's either there or not.
Yes, but even if it exists, but I mean, I think
yes, you can't.
my friend's point was, well, it might, if it exists, but you don't look at it, it still exists, and that's the same as a boundary, but it doesn't work. So a boundary is a physical feature you can go and look at. A document that you don't necessarily have access to can't be used to construe. There were two other brief points on ground. One is in the supplementary bundle, page 139. This was an example of, it was said in the freehold transfer, another place where there's reference to leasehold matters, as it were. And we can see at the top of page 139, paragraph 2, reference to the incoming tenant. In my submission, that's quite obviously a typographical error. There's nothing involving tenants in the freehold transfer. This is a deed of covenant between a vendor of the freehold estate and the purchaser of a freehold estate. It's just an obvious typo. It says, I mean, this is, so nothing turns on that. It cannot be construed in any other way. And the other reference was paragraph 8 on page 117. Paragraph 2 of part 8. Which also...
The last but one line.
Yes, and it also references and under the leases. So this is the point that the owner can compel the unit holders to purchase, take the land off his hands and put it in the name of the management company. Well, you don't need to know what the terms of the leases are. The reference to leases there is just any land that happens to be held on a lease or has been transferred, you all have to jointly buy it. You don't need to know the terms of the lease. So that, in my submission, just takes us nowhere on the point. On, I think that those are the only points I wanted to pick up.
Thank you.
Ground 1. Ground 2, this point about a public agreement. I think we've got to remember the focus is on what is the nature of the freehold transfer. And the nature of the freehold transfer is it is a public agreement. The focus isn't upon whether the lease is a private document or a public document. The focus is on the freehold transfer. That's a public document. Therefore, the rules by which we construe it are in light of Cherry Tree, such that other documents that are not available to you, and if they're public documents, they will be available. If they're private documents, they won't. They have lesser weight. So we've got to focus on the right document. And the Section 106 agreement is quite obviously a document that is available. And one of the points that was touched upon in one of the friend's submissions was the extent to which the Section 106 agreement should be afforded weight when you construe the freehold transfer. And my learned friend says, yes, it's relevant background, but it doesn't define the obligations. And the point I wanted to draw out here is if we look in the freehold transfer, it defines what Section 106 agreement is. It specifically references it. It effectively incorporates it because the obligations on the part of parties, including the appellant, are to comply with the Section 106 agreement as defined. Whether we say the Section 106 agreement is incorporated within the freehold transfer, or we say you cannot understand the obligations in the freehold transfer without reference to the Section 106 agreement, however you put it, the Section 106 agreement must affect the obligations of the appellant and indeed the freehold management company, because you can't read it any other way. The parties have expressly made reference to a particular document that is available, freely available. There was a point about insurance. That was on page 125 in the supplementary bundle. You may recall this was 7A, my lord, yes. I think the point that was being made is, well, it's to be insured by the freehold management company in the names of the transferor and the freehold management company. Unclear why the freehold management company needs it insured in their name because they don't have an insurable interest. The transferor, as the owner of the estate, has the insurable interest. And somebody's got to insure it, and they've said it's the freehold management company. But nothing turns on the fact that the estate management company isn't mentioned as a party in whose name the insurance should be placed, because the estate management company doesn't, on the face of it, own it and then have an insurable interest. Now, in fact, the estate management company now owns parts of the estate, the chapel, some of the common areas, but that means it is a transferor, because if we look at the definition of transferor, it includes successors in title. So once one analyses where it all takes you, it's a neutral, it doesn't answer the point.
As I understood the point that Ms. Patson was making about this was that here we have the retained parts, which you say include the facade and the structure of the Mostyn House School building being insured, and it's the freehold management company which has a responsibility to insure it, not the estate management, not your management company.
Yes.
And well, the point made was that if you were the body that was responsible for the retained parts, surely it would be your company that would be responsible for the insurance. That's, as I understood, part of what she was submitting.
I do understand those submissions, but I say it just doesn't make sense, because the question of who's responsible for maintaining the property is not the same as the person who has an insurable interest, because these are tripartite agreements where you have the owner and a separate management company.
It's very hard to understand why the freehold management company has an insurable interest in insuring the building of the Mostyn House School buildings.
Has any, rather than an insurable interest, has any interest.
Any interest. Yeah.
I agree, but the same is true for the leasehold management company. The problem is retained parts incorporates both halves.
Well, there are very few retained parts in the freehold estate.
Yes, but the definition of retained parts is across the development, not across the estate.
No, well, it's unobvious.
mean, ultimately, the party with the insurable interest is the owner of the land. That's the transferor. And they're the party that need it insured. Anyway.
And the management company is only in default. The insurer, I think it's.
Yes.
Yeah.
Yes. I mean,
Just to be agency, including the transferors, as decided from time to time by the transferor or in default the management company.
Yeah.
Okay.
Well, I think you picked up on this point. Well, what is the distinction between the communal areas and the retained parts? And I accept it's a grey area, and it's difficult to work out the precise delineation. They do. The starting point must be we assume they were intended to differ. If I have to accept that, but that doesn't mean that they don't overlap, because we've got lots of examples of overlapping. And that overlapping is unavoidable. If one looks at the definitions, on page 109, communal areas includes the communal facilities. And communal facilities includes the service installations within the communal areas which serve the properties on the development. And then we have the service installations definition over at 18, and then at 16 we also have reference to the service installations. I think the estate roads, do they overlap? The roads on the development, the communal areas include.
Doesn't mention the road.
Well, communal facilities limits the estate roads.
Communal facilities. The roads.
Yeah, it's quite circular, but the focus here is on the definition of communal areas, and I can see that areas might be read, as I said earlier, might be read as land, open land, as opposed to all land, or it could be given even that very at the other extreme, which isn't the extreme I take it to, the corridors.
Yes.
My lord was talking
probably
about.
Does include if you're in. I've got a mental picture of what it must be like inside the old school block with the apartments. There will be communal corridors, not owned by any of the.
Yeah, because it's not included within a lease. Communal areas is the bit the estate management company does. The retained parts is the bit that, strangely, the freehold management company and the leasehold management company do, even though they can't recover the cost of all of the things they're obliged to do. I can't really take it much further than that, other than say there's different definitions for different parties. As I say, my principal case hangs on complying with the 106 agreement, not on the definition of communal areas. That's really a sort of
Your
add-on, as it were.
Part 12, paragraph 6.
My lord, yes.
Primarily. But if that, and it is important, this distinction, if there is one, between communal areas and retained parts, because paragraph 6 does not refer to the retained parts.
No.
It limits,
Retained parts
your obligations there to the communal areas and the communal facilities.
Yes. Retained parts is a freehold management company term, if I can put it that way.
Yeah.
And communal areas is an estate management company term.
Yeah.
But there is an absolute overlap on compliance with section 106. There was a point on the step-in rights in the lease, and that's paragraph 7.24 in the lease, supplementary bundle 76. This is if the estate management company or the leasehold management company fails to perform its obligations, the landlord steps in. And as I understood the submission, it said, well, why does management revert to the freeholder and not the estate management company? Well, the isn't the answer to that. If the step-in right is because the company has failed to perform things, the company can't step in to address its own failures.
No.
So I might have missed the point, but I think that's the answer if I understood it correctly. And I think the other point that was made in the lease context was to say, well, leaseholders, let's say the estate management company does these works, and some of the leaseholders think that's not right, because if the leasehold management company had done it and it only related to the one building, the one estate, half the building, they might have only had to pay half because of the way the apportionment works. Well, number one, you can vary the proportions. I took you to that earlier. That's one possible answer. Number two, we've got to give effect to the words in the document. I'll come back to that. And number three, well, the very fact that there's the potential for challenge by leaseholders in the tribunal, not freeholders, but the potential for challenge is a factor that the appellant's going to have to take into account in deciding whether it's appropriate for it to be the party that does the works to the school or another party. And I go back to nothing about these proceedings are intended to exclude the other parties from doing it. We're establishing the point of principle about whether the appellant can do it. Not to the exclusion of others.
No, but
That's
the,
not
the,
the
the different charging regimes and the ability to bring the freeholders in to a responsibility to pay the charges may well dictate which vehicle is chosen.
It may do, yes, but that decision is going to have to be...
Litigation is all about. Yes,
but I mean, that decision has to be made with one eye to the risk of challenge as well, doesn't it? By whichever party does it. You've always got that problem. And the last point on ground two, and I'm going to quickly run through ground three, was...
just sitting here, and as a lawyer who in a different field is in very favour of mediation, it's probably far too late to think about it, but it seems to be highly undesirable for everybody involved in this to be stuck here. There's lots of people can't sell their houses and move on. There's this dispute going on. They're living in an area with, presumably, they all chose these dwellings partly because they find the area attractive, the school where it is, the frontage on the River Dee, and yet they're falling out. I don't know whether mediation has been thought of at all. It's never too late to think about these matters. I'm not going to ask about that because I don't want to be.
I can't answer the question.
I don't want to be influenced by the answer. So this is me just having a letting off of steam rather than expecting any information back. But I would, whatever the end of this appeal, it won't necessarily solve everything.
It won't.
Here.
It won't.
Well, whatever the result of the appeal, and it's an unhappy state to be in, to be stuck like this. So I simply mention it. It's never too late to think of other ways of resolving disputes and coming up with a positive agreement as to a compromise that allows everyone to move forward and draw a line under this. But that's the end of my rant. But I felt at some stage I wanted to have it. So thank you for listening.
No, my lord, I can't say much more. But
no, I think I don't want information.
But what is clear is this is not going to resolve all the problems of construction. I don't suppose today would be a happy affair if we were working our way through the answers to all of the potential problems. This arises because it's the most important thing on the appellant's list of things to be done. But I mean, there's other disputes floating underneath, as you can imagine, between the parties, and one way or the other they need to work it out.
The state was only created in the last decade.
Yes.
All will have bought happily, thinking, well, this is where we want to be.
Yeah.
And here we all are.
Yes.
Anyway, there we are. I interrupted.
It was just the last point I was picking up on, I'm turning to ground three, was I think it was being said, and I don't know if you'll correct me if I'm wrong, that the estate management company doesn't have rights of access to do the works. And
I think that was that because there's the only right of access, it's Part 13, Paragraph 7, if this is the same point, exists for the company if they've got an obligation to do the work. And if they haven't got an obligation, then they haven't got a right of access. And that's what was being put, if I remember.
Yes.
Yes. Well, I suppose So two answers to that. One is, well, that's sort of just, if we've got the obligation, then we can go in and do it, so great, and that's the end of it. And if we haven't got the obligation, we shouldn't be going in anyway. So I suppose that doesn't, I don't know where that takes us. But the other point is, if we look at paragraph...
Well, it was in the... Yes, I think that's right.
If we look at paragraph 10 of page 1, on page 121, positive covenants by the transferee, and whilst I accept this isn't a covenant with the estate management company, it is a covenant to permit the covenantees, which includes the appellant, access to carry out works to the development. So we have a right there as well. And you have the same mirrored in the lease at clause 7.7 on page 72. So I don't think the access point is an answer in my submission. My Lord, may I turn to just quickly responding on ground 3?
Yes.
You've seen my initial point. My initial point is to say, well, it should go back to the trial judge. It's said that you have all the information before you, but if you saw the state of the supplementary bundle before it was rescinded, there was an awful lot of documentation and evidence, particularly witness evidence, before the judge. You have a flavour of some of the witness evidence in the supplementary bundle, which we have not taken you to. Gives you an idea of why the proceedings were issued and the views of the parties. Doesn't take you anywhere on objectively construing a document, but it may be relevant to the appropriateness of the declaratory relief. And I accept, and we'll come to this in terms of if you exercise the discretion, I accept it's not going to resolve everything. We're not asking the court to resolve everything, we're asking the court to resolve this point, and we're going to have to work our way through it unless and until the parties reach agreement. One of the things that stands in the way of reaching agreement, of course, is unless you vary the documents or you have unanimous agreement amongst 85 people, it is very difficult because you have to have a cohesive scheme.
Yes.
That's the great difficulty. And it's not, there are processes by which you can vary all the leases, even if not everyone agrees, but those processes do not exist for the freehold transfers. So there is provision for the tribunal to vary the leases.
So just thinking of it, if we get to the position of considering ground 3, it's because we have concluded the judge was wrong in his conclusion on the primary question. We will have concluded that the leasehold management company is entitled to the terms that you think. So then the question is, do we make a declaration of? But in our judgment, we would have said the leasehold management company is entitled. I think
that's right.
And so then that leaves it as a question whether there's a declaration or not. There will be a public judgment from the Court of Appeal. Yes.
Well, I mean, that was my next point, is to say, even if the formulation of the words is wrong, really the purpose of these proceedings is to find out the answer to this question, which we're going to get anyway. And if it's, that's not me abandoning that we want declaratory relief, but it is a slightly odd distinction.
I think it needs thinking through on our part.
We're just looking for an answer to how you construe the documents, and that's what the declaration reflects.
But I am, as the observations I made to Ms. Matson, troubled with your application for us to make a narrow declaration on one bit of what is quite a complicated set of relationships, and that would somehow give that a priority and give you a green light on that bit when we haven't got the whole picture.
Yeah, so
it may further imbalance a matter that is out of balance in any event.
Well, I think the answer to that is we're going to get the answer anyway, but that's not a good answer.
No, it's the one I came up with.
Well, I don't mean it in that sense. I mean it in the sense that you're still left, if that's right, with an imbalance. But I say it's not really an imbalance. It's just that there's a lot of things to be worked through. But the point that would be taken against me would equally be, well, if this was a very wide declaration seeking to declare everything, it would be said, well, there's no context to it. You have to have a narrow declaration, or you're never going to get it. And it's a narrow declaration that's sought because there are very significant works that will be required to the school that are expensive, and that's why that's the thing that it's worth investing the time and money in, and it's not worth arguing over who should pay for the particular strip of grass that needs to be cut between the car park and the path, whatever it is. It's there's some commercial reality here. So that's I suppose my response on that. Ultimately, it's a discretion. The trial judge expressed his impression, which was, had he come to a different view,
then he would have made the declaration.
He would have made
the absence of the other players.
So if I may, I just want to there were those Rolls-Royce case points that are in my friend's skeleton argument. Core bundle, page 67.
What paragraph of the skeleton argument?
Paragraph 30.
Thank you.
There's no dispute between us on the principles to be applied, so you have them in my friend's skeleton argument. We're in agreement. And I'm looking at paragraph 30, and we've got a list of considerations. Well, number one, it's discretionary. We've discussed that to an extent. Number two, there must in general be a real and present dispute. Quite clearly there is. Both sides are engaged in a bit of long-running dispute over this, and these are long-term agreements. So the fundamental points. Yeah. But you don't need to have a present cause of action, so we don't need to be suing on an invoice, although there is an invoice in the supplementary bundle which relates to an initial survey. Third point, each party must in general be affected by the court's determination of the issues concerning the legal right in question. Well, each party to these proceedings clearly is. I don't think there's a dispute about that. 4 relates to non-parties. It's not in the sense of non-parties to the contract, where the claimants are non-party. That doesn't arise here. And then 5, the court will be prepared to give declaratory relief in respect of a friendly action or where there's an academic question, even on private law issues. This isn't academic. It's a very real dispute, and it's better to know before you spend the money when you're a management company with no commercial income than after. 6, and this is where we get to one of the significant disputes between us, the court must be satisfied all sides of the argument will be fully and properly put. It must therefore ensure that all those affected are either before it or will have their arguments put before the court. So the point that's made is, number one, the freehold is not a party, that's grey. They are the freehold owner of the leasehold half of the estate, excluding the chapel. You have the office copy entries in the supplementary bundle. Well, what possible prejudice is there to grey? All that's being argued about is whether, at worst, an additional party can maintain the school buildings. From its perspective, it wants someone to be liable on the Section 106 obligations. That's not it, because it is primarily liable, and then it's getting passed down the chain. So it's looking for compliance, ideally more than one party. So it's hard to see how it's prejudiced. But in any event, the arguments are before you pretty comprehensively. This is not a case, as you'll see in some of the authorities, where parties go for declaratory relief and the other side either don't respond to the claim or respond and say they object but then don't put in any evidence. And then the court's left with the very unsatisfactory position of it's essentially unopposed, but because of the nature of declaratory relief, how can the court be satisfied it's had all the arguments put before it? I say you've had all the arguments. In terms of the leaseholders, paragraph 3 in the core bundle, page 83, you'll see the judge records that he was told the leasehold owners have not been joined as parties, but they unanimously support the company in bringing the present claim and agree to be bound by the decision. That is backed up also in, if you look on page 7 in the supplementary bundle, it's in the details of claim verified by a statement of truth, and it's in a witness statement at page 12 in the supplementary bundle at paragraph 17. So that deals with the leaseholder point. The leaseholders are in control of the estate management company and the leasehold management company. The leasehold management company is a party but hasn't participated because what more would it say? The leaseholders, what more would they say Now, my learned friend to that says, oh, they make this point about different halves of the estate, but no relief is sought as against them in respect of their liability to pay. They're not parties to the freehold transfers. So that's that point at 6. And then in 7, is this the most effective way of resolving the disputes raised? Well, really, that's the point we were discussing a moment ago. I say it's better to resolve it before the money is spent than after. So that's how I say the tests are applied. And then just picking up on, I think, 2 points left. In terms of Gray, it was said, well, Gray might say, well, I'm not very happy with the estate management company taking over responsibility. That's not what the estate management company's doing. They're seeking a declaration as to their ability to do the works, not taking over from another party. I'm not saying the leasehold management company can't maintain its, the buildings. So it's not a question of taking over, it's parallel liabilities.
But the commercial reality is that they would take over the substantial work because of the bonus that the leaseholders would get by being able to offset 50% of the charge in round terms onto the freehold owners.
Well, that might be the case at the present time, but it might not be the case at another time. It doesn't change the leasehold.
I think your points sound a bit sound without that observation from me. Gray's got no, as long as someone's doing it.
Yes.
Gray's got no real interest as to which, because in the end it's about who pays the bill rather than who does the work. That's what the dispute's really about.
It is, yeah. And I mean, just stepping back, the leasehold owners, you can have your cynic's hat on and say, oh, they're just doing this to save some money, but you can also have your hat on that says, well, actually, look, that's what was always intended. The section.
If the leasehold management company or the estate management company were to decide what work needed to be done, which builder to use, etc., they're highly likely to choose exactly the same people and do the same things because they are the same people, I'm expecting, largely. And the only difference is who picks up the bill, how is the bill allocated?
Yes, but I suppose that's right, but it might depend on the nature of the works, and if it was minor works to one half of the building, it might be the leasehold management company took the view.
Talking about in very round terms.
But also, it may turn in part on the membership of the estate management company from time to time.
Yes, there may be differences, but yeah. Good.
Well, if I can just check my notes, I think really I'm there. My overarching submissions are my skeleton argument. It's not a case with substantial disputes of fact. It's a straight construction point, and that's why I say it's suitable for declaratory relief. But really, the trial judge is better placed in an ideal world.
Good. Well, thank you both, and Miss Sage. We got there. There was a time when I wasn't sure. We'll adjourn simply adjourn now. It won't surprise you that we will reserve our judgments in this case. We'll endeavour to deliver them as quickly as we can, but you'll know that these things take some time. We'll circulate the drafts on the usual basis to encourage identification of the inevitable typographical errors, but no more substantial dispute. And there'll be no need for anyone to attend on the day that we hand the judgments down, which may be done remotely. Yes. Thank you.